Hello, and welcome to Law Unwrapped, where we simplify the law to empower your future. Today, we're tackling a topic that can feel devastating: what to do when your asylum application has been denied. You came to the United States searching for safety, for a new beginning, for hope. Receiving that denial letter can feel like a crushing blow, like the end of the road. But I want to tell you right now, legally, it is not the end. There are important steps you can take to appeal, to reopen, and ultimately, to win your case. This video will guide you through that process. First, let's understand why your application might have been denied. The key to moving forward is to know what went wrong the first time. The most critical document you have right now is that decision letter from the immigration judge or asylum officer. Read it carefully, multiple times if you need to. It will explain the specific legal or factual reasons for the denial. Common reasons for denial often fall into a few categories. Maybe there were inconsistencies in your story. What you wrote in your application might not have perfectly matched what you said during your interview. Details matter, and any perceived contradiction can be used to question your credibility. Another common reason is missing evidence. Perhaps you mentioned a threat but didn't provide a police report, or you described a medical issue without submitting a doctor's letter. Proving your claim requires strong documentation. The one-year filing deadline is another major hurdle. If you didn't file for asylum within 1 year of your arrival in the U.S. and couldn't prove that you qualified for an exception, your application might have been rejected on that basis alone. Finally, and this one can be the hardest to hear, the officer or judge simply might not have believed you. They may have found your fear of returning to your country not to be credible or well-founded. The decision letter will outline why they reached this conclusion. Understanding their reasoning is your first step to building a successful appeal. Once you understand why you were denied, the clock starts ticking. This is incredibly important. You generally have only 30 days from the date of the decision to file an appeal. This is not a lot of time. Missing this deadline means you could lose your right to appeal forever. Your appeal is filed with the Board of Immigration Appeals, or the BIA. To do this, you must file a document called Form EOIR-26, which is the Notice of Appeal. Along with this form, you must submit a fee or a fee waiver request if you cannot afford it. You also need to explain, in writing, why you believe the judge's decision was wrong. You can't just say "I disagree." You need to point out the specific legal or factual errors. For example, the judge ignored the country conditions report I submitted, or the judge misinterpreted the law regarding my particular social group. This is not the time to introduce new evidence. The BIA's initial job is to review the existing record from your first hearing to see if the judge made a mistake. Think of it like a referee reviewing a play in a sports game. They are looking at what already happened. So, if the appeal is just about reviewing old information, how do you strengthen your case? This is where strategic thinking comes in, and often where new evidence plays a vital role, especially for other options beyond a direct appeal. While your appeal is being prepared, you and your legal team should be working to gather new and stronger evidence. What can you add that you didn't have before? Could you get sworn statements or affidavits from witnesses who can corroborate your story? Can you find an expert on your home country's conditions to write a report? Did you get a new medical or psychological evaluation that details the trauma you experienced? Go back to the reasons for denial. If they said your story was inconsistent, can you find documents or a witness to clear up the confusion? Write a detailed declaration explaining the misunderstanding. Maybe you were nervous, or there was a translation issue. Explain it clearly. What if your situation has changed since the denial? If new dangers have emerged in your home country, or if you are now being threatened directly, this is critical new information. This might not be for your initial appeal to the BIA, but it can be the foundation for something called a motion to reopen. Let's talk about that. Motions are powerful tools. There are two main types you should know about: the motion to reopen and the motion to reconsider. A motion to reopen is used when you have new, previously unavailable facts or evidence that are relevant to your case. For example, if a new law passes in your country that puts you in danger, or if a key witness is now willing to testify. This motion essentially asks the judge to take another look at your case in light of this new information. A motion to reconsider is slightly different. This is used when you believe there was a legal or factual error in the original decision. You are arguing that the judge applied the law incorrectly or overlooked a key fact that was already in the record. Like an appeal, these motions have strict deadlines. You generally have to file a motion to reconsider within 30 days of the decision, and a motion to reopen within 90 days. There are some exceptions, especially if your motion is based on changed country conditions, but you should always aim to file as quickly as possible. Now, I want to be very direct about this next point. Immigration appeals and motions are extremely complex. This is not a DIY project. A single missing form, a poorly written argument, or a missed deadline can have your case thrown out permanently. You should not fight this alone. It is absolutely crucial to seek help from a qualified immigration attorney or an accredited representative from a nonprofit organization. A good legal professional will know how to navigate the BIA's procedures. They can analyze your denial letter, identify the legal errors, and write a persuasive legal brief on your behalf. They know what kind of new evidence is most effective and how to present it properly. Crucially, if you are facing deportation, an attorney can file a request for a stay of removal, which is a legal order to stop your deportation while your appeal is being decided. Trying to handle this process on your own, while under the stress of a denial, is an unnecessary and dangerous risk. While your case is pending, it's natural to feel anxious. But there is a crucial protection in place. As long as your appeal or motion is properly filed and pending, you generally cannot be deported. This gives you time. During this period, stay calm and stay informed. You can track the status of your case through the EOIRS automated phone line or their online portal. It is also your responsibility to keep the court and USCIS updated with your current address. This is non-negotiable. If they send a notice to your old address and you miss a hearing or a deadline, you could lose your case automatically. Always file Form EOIR 33 to report any change of address. I know this is a lot to take in. Receiving a denial feels like a judgment, a final word, but I want you to reframe that. A denial is not the end. It's an opportunity to review, rebuild, and resubmit your case the right way, with more evidence and stronger legal arguments. Many people who are initially denied go on to win their asylum cases on appeal or through a motion to reopen. It takes preparation, professional help, and persistence. Remember the words we live by here. Law is not punishment, it's protection. If you understand it, a denial is a challenge, but with the right knowledge and the right support, it's a challenge you can overcome. Thank you for watching. I hope this information has given you clarity and a renewed sense of hope. If you found this video helpful, please give it a thumbs up. Subscribe to Law Unwrapped for more content that empowers your future, and share it with anyone who might need to hear this message. Stay strong, and we'll see you in the next video.